Marriage age in Christian lands in the past. Anne Mowbray, Duchess of Norfolk, was married in 1478 at the age of 5, to Richard of Shrewsbury, the younger of the princes in the Tower. She died in 1481 aged 8. Cecile of France, aged 8/9, was married to Tancred, Prince of Galilee, aged 30/31, in late 1106. As he was dying in 1112, Tancred made Sibylla of Anjou, aged about 11, was married to William Clito, aged 20/21, in 1123. To Henry the young king, aged 17, in 1172. They had been betrothed since 1160, when Margaret was about 2 and Henry was 5. Eleanor of England, daughter of Eleanor of Aquitaine and Henry II of England, married 15-year-old Alfonso VIII of Castile in 1170, when she was about 9 years old. 1396, King Richard II of England, a 29-year-old man, married the 6-year-old Isabella of Valois. Isabel of France, 1389–1409, in the United States 1880s, most states had the age of consent set at ages 10 or 12, except for Delaware, which lowered it to 7 years of age. Is this proof that Christianity is evil? Do Christians have the moral high ground? The Catholic Church allowed contracts for marriage at 7 years old until the 1917 Code of Canon Law, so, prior to 1917 could marry a 7-year-old. Minimum ages of criminal responsibility in the Americas. As part of CRIN's policy work on the minimum age of criminal responsibility, MACR, we monitor these ages around the world. This page provides detailed information on MACRs in Oceania. If you are aware of any inaccuracies or reforms underway to amend the relevant laws, please contact us at info@crin.org. You can also keep up to date with the latest children's rights news by our 32 subscribing to our weekly email newsletter, CrinMail. Antigua and Barbuda children can be held criminally responsible from the age of 8. Child Justice Act 2015, Section 5. Argentina. No person can be held criminally responsible for anything done while under the age of 16. A child older than 16 but younger than 18 can only be held criminally responsible where the offense is punishable by deprivation of liberty for more than 2 years. Ley 22.278, Regimen Penal de la Minoridad. Bahamas. Children under the age of 10 cannot be held criminally responsible for any act, and a child under the age of 12 can only be held criminally responsible where he or she has attained sufficient maturity of understanding to judge the nature and consequences of his or her conduct in the matter in respect of which he or she is accused. Penal Code, Section 91, 1 and 2. Barbados. No offense is punishable when committed by a child unless the court is of the opinion that the child is older than 11 and has sufficient capacity to commit crime. Juvenile Offenders Act, Sections 7 to 9. Belize. No one can be held criminally responsible for anything done while under the age of 9. A child older than 9 but younger than 12 can only be held criminally responsible where he or she has attained sufficient maturity of understanding to judge of the nature and consequences of his or her conduct in the matter in respect of which he or she is accused. Criminal Code, Section 25, 1 and 2. Bolivia. People can be held criminally responsible from the age of 16. Penal Code, Article 5, but can be subject to socio-educative measures from the age of 12, including those amounting to deprivation of liberty. Childhood and Adolescence Code, Articles 222 and 223. Brazil. The minimum age of criminal responsibility is formally identified as 18 in the Brazilian Constitution. If a person is under the age of 18, an alleged criminal offense is considered an infraction and the person would be subject to socio-educative measures. If over 12, the measures may include community service and partial or total institutionalization in a socio-education facility. If under 12, the child can be placed in a foster home or with a family, among other measures including psychological accompaniment and mandatory attendance of classes, which can also be applied to children older than 12. Constitution, Article 288. Child and Adolescent Code. These measures have led some commentators to report that the minimum age of criminal responsibility is 12, as this is the point at which penalties indicative of criminal responsibility, most notably deprivation of liberty, can be applied. See Cipriani, Children's Rights and the Minimum Age of Criminal Responsibility. A Global Perspective, Ashgate, 2009, pp. 94–97 and 192. Canada. No person can be convicted of an offense in respect of an act or omission committed while under the age of 12. Criminal Code, Section 13. Chilean legislation describes the minimum age of criminal responsibility as 18, but child offenders can be subject to socio-educative measures, including deprivation of liberty, for criminal offenses from the age of 14. Law 20.084 on the responsibilities of adolescents for criminal conduct, Article 3. Colombia. Children can be held criminally responsible from the age of 14, but are subject to the juvenile penal responsibility system, under which they do not establish a criminal record. Childhood and Adolescence Code, Articles 139 and 159. Costa Rica. The Penal Code describes 18 as the minimum age of criminal responsibility. Penal Code, Article 17. Though children can be subject to penalties including deprivation of liberty from the age of 12 under the juvenile justice system. Juvenile Penal Justice Law, Articles 1 and 6. Cuba. Under the Cuban Penal Code, only people over the age of 16 can be held criminally liable. Penal Code, Article 16. However, there is no minimum age at which children can be subject to penalties, including deprivation of liberty in Ray Education Center. See Cipriani, D. Children's Rights and the Minimum Age of Criminal Responsibility. A Global Perspective, Ashgate 2009, at page 195, fn. 30. In effect, 16 is the age of criminal majority, the point at which children can be sentenced to adult penalties. Dominica. No person can be held criminally responsible for an offense committed while under the age of 12. Children and Young Persons Act, Section 3. Dominican Republic. Dominican legislation asserts that people can be held criminally responsible from the age of 18, but children can be subject to penalties including deprivation of liberty from the age of 13. Different rules and sentences are set for children under and over the age of 15. Law 126/03, the Code for the System of Protection and Fundamental Rights of Children and Adolescents, Article 223. Ecuador. The Penal Code asserts that the minimum age of criminal responsibility is 18. Penal Code, Article 40. Though children can be subject to penalties including deprivation of liberty from the age of 12. Childhood and Adolescence Code, Article 3055. El Salvador. The Penal Code asserts that 18 is the minimum age of criminal responsibility, though children can be subject to penalties including deprivation of liberty from the age of 12. Juvenile Penal Law, Article 2. Grenada. The Juvenile Justice Act 2012 was enacted in October 2012 and would make substantial amendments to Grenada's juvenile justice system, including by prohibiting life imprisonment for any offense committed while under the age of 18. However, at the time of writing, this act had not come into force. Until the Juvenile Justice Act enters into force, the sentencing of children is largely governed by the Criminal Code. This profile sets out both sentencing regimes. Criminal Code. The Criminal Code sets an absolute limit on the minimum age of criminal responsibility at 7, by providing that nothing is an offense which is done by a person under that age. Criminal Code, Section 50, 1, Juvenile Justice Act 2012. Under the Juvenile Justice Act 2012, a child under the age of 12 would be presumed capable of committing a criminal offense, and children under the age of 12 could only be held criminally responsible where the state can demonstrate this responsibility beyond reasonable doubt. In deciding whether a child under the age of 12 can be held criminally responsible, the Director of Public Prosecutions, the prosecutor or the attorney representing the child could order the evaluation of the child by a suitably qualified person to be conducted at the expense of the state. Such an evaluation would have to include an assessment of the cognitive, emotional, psychological and social development of the child. Juvenile Justice Act 2012. The absolute limit on the minimum age of criminal responsibility at 7 years will remain in force. Criminal Code, Section 50, 1, Guatemala. The Constitution asserts that a person can be held criminally responsible from the age of 18. Constitution, Article 20, though children aged 13 to 18 can be detained in institutions. Childhood and Adolescence Integral Protection Law, Article 2. Guyana. No person can be held criminally responsible for an offense committed while under the age of 10. Juvenile Offenders Act, Section 3. Haiti. Persons aged 13 or more can be sentenced to penal measures under the Penal Code. Penal Code, Articles 50 and 5. Honduras. Under the national definition, criminal responsibility begins at 18, though children can be held responsible under the juvenile justice system from the age of 12. Childhood and Adolescence Code, Article 180. Jamaica. No child under the age of 12 can be found guilty of an offense. Child Care and Protection Act, Section 63. Mexico. The Constitution of Mexico requires states to establish a system of justice applicable to children between the ages of 12 and 18. Children under the age of 12 can only be subject to rehabilitation and social assistance. The precise formulation of this system varies between the states. Constitution of Mexico, Article 18. Nicaragua. Under the definition of criminal responsibility used in national legislation, criminal responsibility begins at 18, though children can be subject to penalties under the juvenile justice system from the age of 13. Childhood and Adolescence Code, Article 95. Panama. Children can be subject to penalties for criminal offenses from the age of 12. Ley No. 40 del Régimen Especial de Responsabilidad Penal para la Adolescencia, Articles 7 and 8. As amended by Ley No. 6 to 2010, Articles 2 and 4. Paraguay. Children can be held criminally responsible from the age of 14. An adolescent can only be held responsible if he or she is of sufficient maturity to understand the illegality of his or her actions. Younger children can be the subject of protective measures. Childhood and Adolescence Code, Article 194. Peru. The minimum age of criminal responsibility is formally 18. Where a person under 18 infringes the criminal law, he or she is considered to have committed an infraction, and can be subjected to socio-educative measures, though these measures include deprivation of liberty. Penal Code, Article 20.2. If under 14, a person can be subjected to protective measures such as tutoring for the child and parents, participation in an educative program or placing the child in a foster family or home. Childhood and Adolescence Code, Article 242. St. Kitts and Nevis. No child under the age of 8 can be held guilty of a criminal offense. Juvenile Act, Section 3. As per initial report of St. Kitts and Nevis to the UN Committee on the Rights of the Child, CRC, C. 3, Ad. .51, the 5th of May 1997. St. Lucian. No one can be held criminally responsible for actions taken while under the age of 12. Children and Young Persons Act, Section 3. St. Vincent and the Grenadines. Children can be held criminally responsible from the age of 8. Juveniles Act, Section 3 in Criminal Code, Section 12. Suriname. No one can be prosecuted for an offense committed while under the age of 10. Penal Code, Article 56. Trinidad and Tobago. The minimum age of criminal responsibility is not defined by legislation and so is governed by the common law. Children under the age of 7 cannot be held criminally responsible for any offense. Second Periodic Report of Trinidad and Tobago to the UN Committee on the Rights of the Child, CRC, c. 83, Add. Point 12, the 15th of November 2004, Para 248, and there is a presumption that children aged 10 to 14 cannot be held criminally responsible, though this presumption can be rebutted where it can be demonstrated that the child knew that his act was seriously wrong at the time when he did it. CC, a minor, versus DPP 1996 1AC1. HL United States of America. The minimum age of criminal liability is set at the federal and state level in the United States. At the state level, 33 states set no minimum age of criminal responsibility, theoretically allowing a child to be sentenced to criminal penalties at any age. Cipriani, D. Children's Rights and the Minimum Age of Criminal Responsibility, A Global Perspective, Ashgate 2009, page 221 and 222, though in most of these states a capacity-related test is applied. Of the states that do set a minimum age of criminal responsibility, North Carolina has the lowest at 7 years, while Wisconsin has the highest at 10 years. For full references of state laws, see the National Center for Juvenile Justice. Uruguay. No one under the age of 18 can be held criminally responsible under the definition adopted by Uruguayan legislation, though children can be subjected to socio-educative measures from the age of 13, including institutionalization. Childhood and Adolescence Code. Venezuela. People can be subject to penalties including deprivation of liberty from the age of 12. Ley Orgánica para la Protección de Niños, Niñas y Adolescentes, Article 528,